Hello everyone, Phyllis Roman with Giamanco Law Partners here to talk to you today about what to do once you have a judgment. You think this is the easy part, you've got the judgment, now you are automatically going to get paid. You proved your case, you've won in court, now you get your monetary damages. Not always the case, unless there's an insurance company or funds on the other side where it may be a very solvent business. It's very difficult many times to get that judgment. We tell many clients that you have a case, you are likely going to win, but you are likely never going to get paid. And they have to make the determination as to whether or not they want to move forward with the case at all. It is much easier sometimes to get that judgment than to get the money that you won. The information in this video is also going to be useful for people who have a judgment against them, so they can know what a company or an individual, if you have been sued and a judgment has been entered against you, you can find out exactly what they can do against your assets and your funds. So this is useful for both sides of the case, as it were, and these are just some of the ways that someone can collect. Now, you have your judgment. What happens if you know absolutely nothing about the assets, where someone works, what money, what accounts an individual may have? The next step is to do a citation to discover assets. You file this with the court, and you get the individual served with it again, and you have a citation to discover assets. The person is supposed to come into court, and they get sworn in by the judge, and they have to answer all of your questions. This is often done out in the hallway, away from where other people can hear. You can ask them about their bank accounts. You can ask them about where they work. You can ask them about any property they have, cars, homes, if they have trusts, if they have any savings bonds, any stocks, really very broad questioning under oath about individual's property. The other way that this can be done that's a little more formal, if someone has a lot of assets, for example, if they have owned businesses, or if they have multiple properties, things like that. The other way you can do it is be sworn in and do it in a deposition format where there's a court reporter present, where the individual brings, you demand a bunch of documents from them about proofs of accounts, business holdings, stocks, bonds, things like that. It can generally be a longer process done with both attorneys present, both your attorney and the attorney for the individual who owes you money, going through all the documents, going through any and all assets in front of a court reporter. After the citation to discover assets is done, you still don't get the money. Now you have to go after the assets you've learned about, and it's possible you've learned that there are no assets, no bank accounts, nothing out there that you can recover against. If that's the case, unfortunately, you kind of have to just hang out and hope that at some point they come into money, that they get a job, or that they get a job that pays better, or they have some sort of assets they come into. If they do have some assets, there's things you can do. There are things that are very, very common that virtually everyone who has a judgment has done. Or there are more uncommon things that I'll talk about in the end of the video that are less common, less used, but still are capable of getting you money. The first and most common two things to go after someone's assets are wage garnishments and non-wage garnishments. Wage garnishment is just what it sounds like. You file a wage garnishment with someone's employer. You send them a bunch of paperwork that the court has fabricated on most of their websites, at least in Illinois, and you send that document to the employer. The employer has some answers that they have to fill out. You go back in front of the judge and say, "Judge, they're working at this location. this is the amount of money they're making. I would like a percentage of their wages. This is pursuant to law, and an equation that's basically drafted out by the legislature. I want a part of their wages to be given directly to me every paycheck. People are most familiar with this in child support, but it can also be done for any other judgment that you have. If you have a judgment for a breach of contract and you know where they work, you can go after their employer. The employer answers all the questions, and a part of their paycheck can be given to you until it's paid in full. That is an extremely common way to go after judgments. It is not the most ideal way in the sense that you're going to get a small percentage every 2 weeks, every week, however this person gets paid. It may be as little as $7 a paycheck, or maybe as much as $150 to $250 a paycheck. It is completely dependent upon how much they make. Not a great way to get paid out on a judgment, because it can last for years. And if they change jobs, you have to start the whole process over again, send the wage garnishment to their employer, and then get the answers back and ask the judge again under that job to get their funds, a percentage of their funds. The second most common way to go after someone for a judgment you have is a non-wage garnishment. This is really going after any funds out there that are not wages, non-wage garnishment. Same as the wage garnishment, except it's for non-wages. So if you know where they bank, if you know someone banks at a particular institution, you send a non-wage garnishment to that institution, and that institution actually freezes those accounts. Then you go into court and say, Your Honor, the bank has informed me that they have $2,120 in their account. I would like you to turn over those funds to me to pay off at least a part of this judgment. Now, the trick with this is a couple of things. One, joint accounts. If there's a joint account, you have to prove, and the debtor, the individual you have a judgment against, has to also be participating in this, whose money is in there. So if it's a married couple and you only have a judgment against wife, and all of those funds are coming from husband's wages, it's unlikely that you're going to be able to get after that account. So you have to be careful with a joint account. Additionally, if you have a savvy debtor, a savvy individual who is who is trying not to pay you, they can come into court, at least in Illinois, and claim what's called a personal exemption. Personal exemption must be claimed by the debtor. If they don't say those words, personal exemption, you can get after their funds. That $2,000 that they had sitting in their account, the judge is likely going to turn that over to you. The bank is going to just write you the check and get it to you, and the freeze will come off their account, and you can keep going after that account. If the debtor goes into court and says the magic 2 words of personal exemption, there's automatically $4,000 you can't touch. If they say personal exemption and they have less than $4,000 in their account, at least that's $4,000 as of 2019 when I'm filming this, if you have less than $4,000 in that account and they say it, you can't get it. The bank account becomes unfrozen and they get back access to those funds. If they have more than $4,000, you can get after that. The good thing for individuals who have judgments is most debtors, most people who have a judgment against them, do not know to claim this. If they don't know to claim it, you get the money. Non-wage garnishments are not only after bank accounts. They can be against other things as well. I had an unusual case where it was trying to go after a retainer. They had paid an attorney in another case, and that attorney had their funds. The non-wage garnishment, mine, I tried to go after those accounts in the other attorney's trust account. Basically saying, you have funds of Jane Doe that should be turned over to me because I have a judgment against Jane Doe. That attorney fought it. obviously. We went into court, and that attorney was able to show that he had actually already earned those funds, that he had done enough work, and those funds were no longer Jane Doe's, they were his. So the court actually denied my motion, but you can see how you can go after other funds. You can get creative about going after someone's money. Another way you can do it is if they have recovery coming to them, personal injury recovery, work comp recovery, something of that nature. You can ask the judge to put a hold on those and do a non-wage garnishment and a turnover order for those funds to pay off your judgment. Though there are a lot of different ways you can do a non-wage garnishment. It really is any monetary money funds other than a wage. There are more unusual recoveries as well, or recoveries that you're less likely to get paid on. Liens. You can ask the judge to put a lien on any property that debtor has. Cars, homes, things like that. Those are harder to get paid out on. If they never sell those items, the lien is essentially worthless. If they do sell them, then you can go ahead and they have to resolve your lien before they sell the property. But if they never sell that property, then the lien just essentially sits there. You can ask the judge to force them to sell properties. That gets a little more involved. And it's unlikely if they only have one car and one home. It's more likely in a case where someone has multiple properties, multiple homes, multiple cars, more likely that a judge is going to grant that they force the sale of any property. And if you're getting into that level of debt collection, you really should be contacting an attorney because they are more familiar with the processes that go along with forcing a debtor to sell property of theirs. A really unusual one that a lot of people don't think of. It's actually an oldie that a lot of people don't think of in using a debt collection, but it can be very, very effective depending on who the debtor is. It's called a till tap. If you have a judgment against the business, so you don't only have judgments against individuals, you can have a judgment against a business, or if it's a sole proprietorship and that person is the sole proprietor and they don't have an incorporation where it's protected, you can ask the judge to physically have a sheriff go in to their business and pull the till. Have them open up their cash drawers, their cash receipts, whatever they've got on property, and actually pull those funds to pay the judgment. It's a little more unusual. A lot of judges aren't familiar with it anymore because it tends to be from an older process, the one that's not used as often anymore, but it's another option for you to get your funds. Really, the whole process of this video is how can you get your money? And if one of those is that it's a business, if it's a restaurant, you have a judgment against a restaurant and they constantly have cash on hand, you can ask the judge, Judge, I would like you to do a till tap and order the sheriff, because you're not going to be able to do it yourself, order the sheriff to go in and pull the funds from all of their tills. That's a little more unusual, but it's possible. There are lots of ways to go after a judgment. It can be difficult. It can be expensive to go after the judgment as well. All of these things that I just listed to you, the wage garnishments, the non-wage garnishments, the till taps, going after bank accounts, going after, and putting liens in there, all of them cost money. And a lot of times it's not worth the grief and aggravation for an individual to go after these funds. If it is, I encourage you to do so. There are ways that attorneys can help. They can streamline the process. The faster you go after the funds, the more likely they're going to be there and not get moved around and changing banks or changing jobs. The faster you can get in there, an attorney can streamline that process to get you in there faster and get you those funds faster. I highly encourage you, if you do have a judgment that is just hanging around and you haven't been able to get paid on it, to contact an attorney. If you have questions, myself and anyone in my office are happy to walk you through collection proceedings and going after a judgment. Please feel free to call our office at 630-635-5555, and either myself, my partner Joe Giamanco, or any of our attorneys would be happy to help you out and walk you through what you need to do to get the funds that you have proven you are entitled to. As always, good luck out there, and I look forward to talking to you next time.